More on this matter and other emerging legal perspectives, we're joined in studio by the Member of Parliament for Yendi, Alhassan Abdul Fattah, who also doubles as a legal practitioner. Thanks for joining us.
Thanks for having me, and good evening to you and everyone.
Right. Let's start with this one. So from Article 146, two distinct processes can be identified, one for the removal of a Chief Justice and another for removal of a Superior Court judge. Would you agree that since the former Chief Justice went through the procedure for removing a Chief Justice, her status as a Supreme Court judge should remain intact unless she's separately removed under the processes for Superior Court judge?
Well, thanks so much. I would have a difficulty in agreeing with that position. Even though if you look at the latter of the constitutional provision as indicated, you may be tempted to draw that conclusion. But you see, you should go behind it and look at it this way. Is if you go and look at the current constitution of the Supreme Court, all those who are members of the Supreme Court, all the justices of the Supreme Court, are automatically qualified to be Chief Justice. Automatically. Because if you look at our constitution, we do not have qualification to be a Chief Justice. Article 128(1) and Article 128(4), those will tell you who can be a Justice of the Supreme Court, who can be a Chief Justice. But if you look at it, they don't have separate qualifications for being a Chief Justice as opposed to being a Justice of the Supreme Court. So it tells you that you require the same qualifications to be a Justice of the Supreme Court and a Supreme Court judge. A Justice of the Supreme Court and a Chief Justice. You require the same level of qualifications. And so if at any point in time, one of the qualifications is lacking, for which reason you can no longer be a Supreme Court, a Justice, a Chief Justice, it means that you lack in becoming what? A Justice of the Supreme Court. I don't know whether you get my analogy.
I do.
It may not be explicit, but because the two positions have the same level of qualifications, Chief Justice, Justice of the Supreme Court, the same level of qualification. In fact, there's no way in our Ghanaian system where a Justice of the Supreme Court can be said not to be qualified to be a Chief Justice. There's no way. Because there's no set different criteria for being a Chief Justice other than just being a Justice of the Supreme Court. And so if at this point you are disqualified from being a Chief Justice, which would have required the same qualifications as being what?
A Supreme Court judge. A
Supreme Court Justice. It means that you are lacking in that regard of becoming even just a Supreme Court Justice. You understand?
Yeah.
And that gives credence to a case that came up, I think, in 1995, 1996, where we have it as GBA versus Ghana Bar Association versus the Attorney General and another, where Justice Pega was explicit that once you are removed as a Chief Justice, you cannot come back and sit there as a Justice of the Supreme Court.
But remember, some argue that that case was arbiter and not binding.
Yes, not that case. We don't say that case was arbiter. That statement in the case was arbiter. Yeah, you can say that. But it lends credence to that constitutional provision. We are not quoting it as a precedent or a stare decisis to buttress this point. But we are just telling you that he came to that conclusion given the provisions that I have just enumerated. 1281, 1284. Same qualifications for being a Chief Justice and a Justice of the Supreme Court. And so it will be very difficult to create any dichotomy. So once you cut, because remember she was moved on the ground of stated misbehavior. Yeah. And it's still a qualification to be a Chief Justice or a ground for even to be removed as a Justice of the Supreme Court. If you come to 146, it's still a provision and a ground to remove you as a Justice of the Supreme Court. If you are found not to have conduct or to have, if you are proven to have some or misconducted yourself, that is stated misbehavior. And so if that ground can remove you as a justice, merely as a Justice of the Supreme Court, and it has already succeeded in removing you as a Chief Justice, that means that that stated misbehavior is now applicable to you. And so once you carry that luggage on you, once you carry it on you, you cannot sit there as a Justice of the Supreme Court. I see her struggling to get back to the bench because of her emoluments, her benefits. And my understanding was that she was given an opportunity to, as it were, resign and then be entitled to her benefit. But she refused it. I don't see how the High Court judge will come to this conclusion that she wants us to agree with. I don't see that happening.
What do you make of the argument that removing the former Chief Justice from the Supreme Court bench when the petitions were not about her status as Supreme Court judge suggests the entire process was premeditated and skewed against her?
No, you see, yes, the petition came to remove her as a Chief Justice. And the petition stated grounds for the removal. And then the provisions as relied in the Constitution also have those grounds. Now, the whole process for her removal went to look at these various grounds. And one of the grounds, like I indicated, the stated misbehavior has been found to be alive.
Right.
You understand? And so you may say that it was not for her removal as a Supreme Court judge, but that can still be described as a lacuna in our laws. Right. Which we have to treat. You understand? And so not until we get there, the fact that it is not stated black and white does not mean that you cannot cross that bridge when you get there. But she may even have to go for constitutional interpretation on this matter. Okay. You understand? Whether or not that removal as Chief Justice, as enshrined in Article 1466, can still be taken to be a ground for her removal as a Justice of the Supreme Court. But it may go beyond the High Court, because once you are going for judicial review, it has to be the High Court. So she's currently at the High Court. Okay. But I see that we may even need a constitutional interpretation. But there's also a golden opportunity we have at hand where we are doing the constitutional review process. I think it's something the Commission has to take up and make sure that that whole provision, 146, is further fleshing out.
Let's turn to Parliament's oversight role under Article 75. Is there any justification for the executive not seeking parliamentary ratification, especially considering the Supreme Court's decision in the Margaret Bamford case?
So which ratification of which specific matter are you referring to? Any decision, any agreement?
The U.S.-Ghana deal in the
so I wanted you to be very specific because
yes.
you were a bit vague. What I feel is something that still has to come back to Parliament for us to ratify, because it's an international agreement. An international agreement can come in various shapes and forms. It can be by memorandum of understanding. It can be by any other means or form. I don't think the nature, the structure of it should excuse it from being captured under Article 75. Right. And so I feel that that agreement, whatever it is. In fact,
is it too late to be laid before Parliament?
No, it's not too late. Okay. Because we have 1,001 of such agreements sitting there that have not been brought to Parliament. Okay. And it is our advice that even when it is late, still bring it. We'll give it that post facto ratification. Okay. You understand? And so I think when Parliament resumes, maybe it's also because Parliament is on recess, where currently you don't have it, and that has to be executed. And so I foresee that when Parliament comes back from the recess, this may be brought up for post facto ratification.
Some have questioned the usefulness of the government's agreement, given that the individuals involved have filed a habeas corpus application against the state. How do you respond to this?
Well, it's their individual right. The government went into the agreement not with those individuals, but with another sovereign state. Right. And so once the government has already committed itself to respecting the terms of the agreement, it doesn't have a choice. It cannot now result from the agreement and then be considering the individual rights of the parties involved. And so I think the government is just acting in consonance with the agreement. Right. We could have said the government should not have gone into the agreement, but once it has gone into the agreement, it has no other option than to follow the spirit and letter of the agreement. And once that agreement is there, regardless of whether it has breached or it has an implication on your rights or liberties, I think the government is right in still following through with the agreement, and so the government has not committed an offense. Okay,
let's turn our attention to Yendi now. Parliament is on recess, and I'm sure you've had the opportunity to be there. What key activities have you been involved in this?
I've been doing a lot for Yendi. I came back 2 days ago. I think the latest activity I undertook was the launch of my the educational scholarship. I call it the Nandambia Educational Scholarship. Which sought to, I think it was just some support I gave to the students, 110,000 Ghana cedis to 110 students who are pursuing various courses at various levels of education. In fact, the exciting thing was that it was oversubscribed, and that means that there's more to be done. We need to look for more resources to help our brothers and sisters in the tertiary institutions. I also had the opportunity to see to the electrification of some number of communities. In fact, the start of some of these projects. But Swano was one such community where we went, the contractor as we speak is on site, connecting that community for the first time in donkey years. They are now in fact, inshallah, coming to see electricity for the first time in their lives, and it was great seeing the excitement on the face. In fact, the chief himself said that, but he made a profound statement. He said he has been in this committee since he was born, and this is the first time that an MP has been elected. And he came back to the community before elections. That anytime they elect an MP, it is only in the next election that brings the MP back. He says, I have come back twice. I came back to do the thank you tour, and I'm back to connect them to the national grid. And so it's been wonderful for me in the constituency, and then we're doing our best to see how best we can address the needs of our people.
Honorable Abdul Fattah, we wish you well.
Thank you so much for having me.
Thank you so much. Now, glowing tributes poured in for the late Asante Hema Nana Kunedu Yadom III.